Chris, may I say something to you while we're waiting?
Sure.
So the stuff in the backyard, inside the fence, are my stuff, and they, of course, have been moved from the north yard and the driveway and the yard facing Pawnee. And of course, I need to sell those because, as you are fully aware, I am kind of indebted to the court for somewhere around $3,000+ on another case. So if the traffic court would waive all my fines, I actually can have all that stuff in the backyard disposed of within 2-3 weeks. But other than that, I need to sell those things to make money to pay the court on the traffic related stuff. That's all I'm saying.
Okay.
Well, there you have it. It's Chris's fault. If you guys weren't harassing me about cleaning my stuff up, I could clean my stuff up. Mr. Lau, we've got a fun one. I think we've got his whatever, the owner of the house, whatever her name. I don't know what the relationship is. Let's give it a look, shall we? Wait. I'll get it going here. Yeah, I had to bust out my a-hole scammer shirt special for Mr. Lau. A-hole status, excuse me.
You could be seated next.
Sorry about this. I thought I had it closer.
Okay, we are on the record. I've got Ms. LeCompte here appearing virtually. We also have Mr. Reynolds here in the courtroom. And I know we scheduled this both for an arraignment session for a new case for Ms. LeCompte and then for a show cause hearing.
Ms. LeCompte.
Mr. Reynolds, I could do the advisement on the new charge, but perhaps before I do that, we could talk about where things stand with Ms. LeCompte's show cause situation in the other case.
Thank you, Your Honor. So I had the opportunity to speak with Ms. LeCompte briefly before this hearing today, and I understand that you just sent in this afternoon 2 photographs, and well, again, you know, there's been some progress. The loose property around the house has still not been completely removed. And as the court is aware, we filed a show cause request earlier this month because there was a lot of other loose property around, specifically in the driveway area and the area behind the residence, and that gave rise to the new ticket. And so it's the city's position is that, you know, she's still not in compliance with the court order to remove all of the loose property.
Okay, so given that, it doesn't sound like there's any type of resolution that's been reached. I want to make sure that before Ms. LeCompte makes any statements, I want to give Ms. LeCompte the advisement that I have to give in every case. So we'll talk about the 2 separate issues. We'll start with the.
I want 1-800-JUNK escorted by a SWAT team. I don't care if they have to soften the battleground with grenades first. I want it gone.
Older of the two cases, case number 2024-2250. And this is a case where Ms. Lecomte, I know you know this, but I'm just making a quick record. Then in October 8th, you entered into disposition on that date and pled guilty to a trash accumulation charge. I imposed a fine of $2,650, suspended all of that fine for 24 months. I imposed 80 hours of community service and suspended all 80 hours of the community service. And it was on the condition that all loose property around the house be removed and that you remain in compliance for that 24-month period. And then we did have one show cause hearing. That following that hearing, I reinstated the 80 hours and suspended 64 of the hours of community service and had Ms. Lecomte perform 16 hours of community service as a consequence when I found that she had failed to comply by still having loose property around the premises. And I also imposed $500 of that fine that had been suspended, and then suspended the remainder of that fine on the condition that there not be any similar violations during the period of that 2 years, and that the property remain in compliance. And then there was a show cause order issued recently, and that was based on a show cause request made by the prosecution. The probation department advised the prosecutor that there was a second offense that had been alleged, new summons number G207353, which is case number 2025-1045. So there was an order that was issued that new charge could in fact violate the conditions of the agreement and the sentence that was imposed in the new case. And that's what the basis of the show cause order was the new charge. There is a new charge in case number 2025-1045. It's again a charge of violating the trash accumulation prohibited ordinance, which is section 633 of the Boulder Revised Code. And because I'm required to in every case, I have to go through an advisement of rights with you briefly to make sure, Ms. Lecomte, you understand your rights. You are presumed innocent of that new charge. That presumption of innocence would remain with you throughout this process, and it would be the prosecution's burden to prove beyond a reasonable doubt that you are in fact guilty of that new charge. You have the absolute right to remain silent throughout this process. You're not required to make any statements about the charges against you, and any statement that you make must be a voluntary one. And as you know, we have a recorder running here today. That means the statements that you are making could be introduced at trial if the new case were to go to trial. If you wanted to, you could apply for public defender representation, or you could hire counsel to represent you. You're not required to do either, but you do have the right to apply for the public defender in connection with this case. And if you were deemed to be indigent, or if you were held to be eligible for the public defender, I could appoint the public defender. Or if you wanted to continue the case over so that you could hire private counsel, you have the right to do that. The maximum penalty that can be imposed for the new charge is up to a $2,650 fine and up to a 90-day jail sentence. Those are maximum penalties. It's unlikely that I would impose an active jail sentence, although I do have the right to do so. And that's why I tell people in advance that I have that legal authority to impose a jail sentence and the fine that I've indicated. Those penalties are maximum. If you decided to plead not guilty and set for trial, it would be a trial in front of a judge or a jury. If you decided that you wanted a jury trial on the new charge, you would have the right to a jury, and that would be up to a 6-person jury. If you decided to plead not guilty and set for trial in front of a judge, it would be a trial in front of me or one of our other judges that appear on occasion in my relief. So that's basically the right. Those are basically the rights that you have in connection with the new charge. The other charge is a charge where there's an allegation that you failed to comply with the sentence, and it would be the prosecution's burden to prove the new charge. And because it's based on a new charge, it would be beyond a reasonable doubt they would have to prove that, but it would not be a trial in front of a jury.
I'm sorry, Judge, I can't really understand you because you're talking quite fast.
Okay.
And it's getting garbled on the Zoom.
Okay, let me slow down for you a little bit. So on the new case, I think I mentioned all your rights. Did you understand all your rights on the new charge?
Yes, I think so.
Okay, on the old case, the allegation is that you failed to comply with the terms of the sentence that I imposed. And the show cause order that was issued indicates that the allegation is that you have a new charge. And if you're found guilty of that new charge, that would constitute a violation of the sentence that I imposed, because one of the conditions of that sentence would be that there be no new
Okay,
charges.
you're breaking up again, Judge. I'm sorry.
So let's do this. Why don't you go off camera? Go off camera for a moment.
Let me go off audio.
No, I think the other way would be better. If you'll go off camera, you can keep your audio on, because I have to be able to hear you say things.
Okay, I did that.
And what I find, Ms. LeCompte, is when people go off camera, if their bandwidth wherever you are isn't as strong, it's usually a little bit better if you're off camera. And so hopefully you're now able to hear me and I'm not breaking up for you. Is that the
Okay.
case?
Yeah, I think so.
Okay, let me know. I don't want.
Okay, here's what should be said, and it's not going to be said, but here's what would be said if I was on the bench, and it would be my last day. That's okay. I never want to be on the bench. If I'm ever on the bench, it'll be for one day. And here's how this goes. I have authorized a JDAM strike on your property. Evacuate now.
You to not be able to hear anything. So I definitely want you to hear everything that's going on. So let me go back and make sure you understood what we were talking about with the old case. The old case, the allegation is that you have a new charge. And if it was proven beyond a reasonable doubt, if the new charge was proven beyond a reasonable doubt, then I would have the authority to reinstate the suspended sentence that still remains on that old case. Does that make sense to you?
Yes.
Okay. There hasn't yet been an allegation, although there could be an allegation that you failed to comply on other conditions in the old case. But the only thing that's currently before the court is an allegation that you failed to comply by getting a new charge. Certainly the prosecution could ask me to, or could on their own, seek to modify the motion for show cause. But right now, just for you and Mr. Reynolds' purposes, because of what I signed off on the show cause on the old case, that's where things stand. If they prove the new case, then I could reinstate the fine and reinstate the community service for the old case. And I would also be able to impose a fresh set of penalties on the new case if you were found guilty of that charge. Does that make sense to you?
Well, I understand it.
Okay, good. Yeah, you may
Your
not
Honor,
agree.
this is Michael Lau.
Mr. Lau, I just need you to be quiet.
Yes.
Okay, so because right now I'm just dealing with the defendant, and so I can't have a second realm of questions. And I know you're an interested party here, but you don't have a legal basis to be heard right now. So to keep things nice and simple and clean, we'll keep it here with Ms. LeCompte. Obviously, if she wants to take a moment to speak with you off camera, I'm fine with her doing that and try to have a conversation with you and she. But I want to keep the proceedings here pretty straightforward. That way we don't get far afield. We're at the arraignment date right now, Ms. LeCompte. So there's a lot of different paths that are available to you. One would be that if you think, gee, I really do want to apply for the public defender and I think I might be eligible for the public defender, you could certainly do that. Or if you wanted to hire private counsel, I could continue.
Why? She's got Lau. He racked up 5 wins in the last edition of this crazy case. He is feeling his oats. He's trying to sham the prosecutor before you even come out, Judge. My God, somebody put an end to this.
Continue both of these cases over for another date for you to seek counsel, or if you need more time to address the issues here and you would like a brief continuance in order to just get through and think about what your next step might be, I could agree to a short continuance. Mr. Reynolds, I would give a chance to weigh in. It wouldn't be a long one because I know that there are interests, including the court's interest, in having these issues resolved in a relatively quick period of time. But nonetheless, because this is a new allegation, if you wanted a little bit of time to gather your thoughts before making any decisions today, you could.
I'd like to speak to the new charge, Judge, and I'd also, I would like to say I have tried to find outside counsel, and I have not been able to find a lawyer that I can afford. So I don't know if I would qualify for the public defender, but that might be something I would like to proceed with. I'd like to.
She looked on Fiverr.
I have explained to
Give a
Mr.
budget of 20
Reynolds,
bucks.
to Pam Albury, and also to the code enforcement people who came by last week and ticketed me again. I would like to speak to that charge because I think I am innocent of additional accumulation around the property. And if I may, I'd like to explain what was happening.
So before you do, let me tell you where you're at. You've got a charge that's pending. So if there's going to be, right now you haven't entered a plea one way or the other on that new charge. And so I can't resolve the case. I don't have the authority. Even if you were Mother Teresa and you said, I didn't do this, I'm not guilty, I can't dismiss that charge right now. So I want to make sure that you understand that. It could go to trial. And at trial, the prosecutor, Mr. Reynolds, could offer witnesses and evidence to support the charge. And you can in response testify and offer witnesses to defend yourself at trial. But right now, even if you said everything that you said to me, I believe, I couldn't dismiss the charge right now because we're not in a trial stage. Does that make sense to you?
Actually, not really.
Well, if you just think about
an
it,
attorney, dummy.
The judge's job is to decide at trial if
Clean your
someone's
yard
guilty
up.
of a violation.
What's
Right
cheaper?
now,
I'd say clean
it's
the yard
just
up.
an allegation that you've committed the offense of accumulating trash. It's merely an allegation. The prosecutor has to prove it at trial. By the same token, a judge doesn't have the authority prior to trial to dismiss a charge before giving both sides an opportunity to present their evidence. And I'm not going to have that today because I don't have the prosecutor and their witnesses here to present their case. Not on the new case. Does that make sense?
Except it makes sense, but that leaves me without any understanding of what I can do to proceed. And I thought I have both complied with all of I've complied with the terms of the earlier probation on the first charge to the best of my ability.
Oh,
We've
sweet
submitted
Jesus.
photographs again
What?
today. I did the community service. I paid the fine. I tried to explain to Miss Albury that the issue of things on the driveway, which is the charge now, new things on the driveway, were things that actually came out of my garage because we were trying to find places to comply with the last remaining parts of the tools and things that were on the driveway at our last hearing and making room in the garage for that. And because the garage is attached to the driveway, there's no way to get them out of there and to be removed, which we were in the process of doing when code enforcement came by and ticketed me for having some things that were removed from the garage, which is attached to the driveway, so that we could load them and move them off. That's what the so-called accumulation of trash was. It wasn't an accumulation of additional trash. And that's why I'm puzzled as to how I can proceed at this point without going to trial, which I really...
Oh my God. Her argument is I'm getting more tickets for the same trash. B, get rid of your trash. Every day is a new offensive violation to the rest of the world. I can't take this case anymore. I've done lost it, people. I can't take it. I'm authorizing the strike. I don't care. I don't think I have that authority to authorize a JDAM strike in Colorado, but to the extent I do, I'm authorizing it, okay?
I can't find a lawyer. I don't want to go to court without a lawyer because I'm not one.
Yeah,
And I feel like
doing a
I'm
horrible
sort of in a
job.
bind. And I don't know how to proceed.
Okay. The new charge, I'm going to turn to the new charge and just so I can address that with you, and I want to read the ordinance to you so that you're aware of what the allegation would be. The new charge is an accumulation of trash charge under section 633 of the Boulder Revised Code. And that alleges that at your address at 290 Pawnee Drive on March 5th of 2025, there was a violation of that particular ordinance. I'm going to read you the ordinance so that you understand what that entails. And I'm pulling it up, so just give me a moment. And are you hearing me okay now? Is it better now that we're with you off camera?
Yes, I can. It's a little foggy, but I can hear you.
Okay, just slow me down if you need me to slow down. It says, no owner of any vacant land or property, occupant, owner, or manager of any single family dwelling
still
or
going?
similar property.
Seriously, get him on the
And then
horn.
it goes on, shall fail to prevent the accumulation of trash, recyclables, and compostables that are visible to the public on such property and on the public right-of-way adjacent to the property. So it includes anything that's visible to the public on your property or on the public right-of-way adjacent to your property. So it can include not only what's on your driveway or in your front yard, but it can include things that are in the backyard if that's visible to the public. So I want to make sure that you have that perspective.
I have that perspective, and that is exactly what I'm saying is not accumulation of trash. It is, there is only one door into the garage. There is only one way to exit things from the garage. So if, for example, I have some piles of my old professional papers that I want to throw away, which is exactly what we're beginning to do, I have to move them out of the garage onto the driveway, sit them down on the ground, and then put them in a vehicle of some kind to be carried off. They are, in fact, visible from the street, but there is no other way to get anything out of my garage except to do it that way. So basically, I'm totally hamstrung. If I am to even clean out my garage for any other purpose, I'm in violation.
Oh,
that
this
seems
is.
very unreasonable to me because you can't get stuff out of the driveway.
She had a team meeting with Lau. They said both of them now. Both of them. We had the little intro where he tried to work on the prosecutor. Both of them are now making a unified argument. It's like watching the press all say the same thing. They're making a unified argument. It's your fault that my place is trashed. Because every time I try to clean it, you ticket me. Oh my God.
Driveway out of the garage without going onto the driveway, which is visible because it's right in the front of the house.
Okay, and we are going to get pretty far afield if we get too much discussing the facts and the allegations. I just wanted to make sure that you understood the ordinance. And keep in mind, I'm not in a position today to rule on whether anything that's alleged is a violation. That would happen at a trial. So
then I am not in a position to go to trial at this point, which I hope you understand. I made a whole lot of phone calls, and people want to, as a retainer, $10,000 to $15,000. I don't have.
Yeah, of course they do.
And I'm sure you know that's the truth.
Yeah.
Well, no, I don't doubt that you're having that challenge. I don't. But let's give Mr. Reynolds a chance. He's been quietly here. Mr. Reynolds, is there anything that you'd like to suggest in connection with the process?
Yes, Your Honor. Thank you. So we were going to have this hearing. It was set today, regardless of whether or not there was a new case.
I'm sorry, I can't understand Mr. Reynolds. He's too far away.
We were going to have a hearing today, whether or not Ms. LeCompte's got another charge, because she's already under a court order to prove compliance with the original case from last year. When we were last in court together on February 24th, the court noted that the property was close to full compliance, and we set it for a review hearing today to see if it is in full compliance. And so I would suggest setting aside the matter of the new case and just continuing the arraignment and just focusing on what she has submitted to show that she's in compliance today for the original case.
Okay. My plan is evolving. I say we send animal control out there. We dart them. We dart them like a rhinoceros that got loose at the zoo. And we take them someplace comfortable and we set them down. We send a team in there and we just liquidate this thing like it's an estate. We send in pros, people who don't care. 1-800-JUNK, a couple attorneys, and we liquidate this whole damn thing. If there's money left over, we give it to them. If there's a balance owed, we make them pay it. That's it.
And and she submitted photographs to Ms. Aubrey this afternoon. And my position will be that those photographs that Ms. LeCompte submitted to show compliance with 24-2250 do not demonstrate compliance.
Okay. Did you hear what Mr. Reynolds said, Ms. LeCompte?
Yeah, yes, I did.
Okay, so, and I agree that when we met in February, I said, let's reset this for March 17th. And the hope was that we wouldn't even have to have a hearing on March 17th was because the folks at the code enforcement people could go by your residence and confirm in their own mind and then let Mr. Reynolds know that in fact you were in compliance. We don't have that type of agreement. Mr. Reynolds obviously looks at this from a different perspective than you do. And I think he accurately reflects what I said on the 24th, which was if we have to have a follow-up hearing regarding whether you've come into compliance, then we would have a follow-up hearing, because I did indicate that show cause hearing that we had on February 24th, and actually that wasn't the show cause hearing, that was the follow-up hearing after the show cause hearing. And let me go back in my document to make sure I'm clear on that.
That's a good question. Alyssa probably knows. It's recent. The last hearing was March and we're in April. So I think there's this. I think there might be one other video coming up.
Yeah, so I wrote that the property is very close to full compliance, set for a review hearing on March 17th. If the property is in compliance, then the city attorney could move to vacate today's hearing. Since they didn't do so, we could have a follow-up hearing. Mr. Reynolds is correct. We could have a hearing solely focusing on whether your property is in compliance as of today's date. It was not in the court's view in complete compliance when we saw you on February 24th. And my order, which was from a prior date, which was the January 8th, I believe, hearing date, or somewhere in January 16th hearing date, that was the date, if you'll recall, where I did find that you were not in compliance and that you had failed to comply. I reinstated the fine, suspended a portion of it, reinstated the community service, and then I said it would be your obligation to pay the fine and do the community service by the next review date. And that's when we scheduled the February 24th date. So technically today's date is for me to determine whether or not you are in complete compliance, because I still had the ability from the prior show cause finding to impose additional consequences. I know that this is a relatively complex process for you, because this is not something that you do on a regular basis. Mr. Reynolds does it as a lawyer all the time. I do it as a judge all the time. So I don't want you to feel where you don't have the opportunity to fully understand where things sit. But that's where they were as of February 24th, which that it was your job to establish to the court's satisfaction by today that you were in full compliance. Mr. Reynolds says he's ready to proceed further with further evidence to support whether or not you are in full compliance, and we could go forward with a hearing. Are you prepared to go forward with a hearing on that sole issue, Ms. LeCompte?
I don't understand what that would entail. I don't know what the conditions of full compliance at this point would be, other than having never being able to remove anything from my garage. So
What would be an issue is what my order of October 8th was originally, which was on October 8th, after you pled guilty, I said that by all loose property around the house needed to be removed.
no, I understand that.
That's the issue.
I do understand that.
Okay, that's what the prosecution would have to prove, is that all loose property has not been removed.
Okay.
That'll be
Is
easy.
it possible to have a continuance to take the thing?
Why are you unnecessarily wasting the judicial time of this court?
Material that came out of my garage is no longer anywhere near the driveway, which was a full intent anyway, which I believe would put us in compliance with the original order, which says that the south side, the
Nailed it.
west
First
side
try.
house, the front yard and the
5
side yard
PG5.
have to have no quote loose property, no trash or whatever items on there.
Well, let me read again what my notes reflected and what I said orally at the court on October 8th. And I'm also going to look at the city's, I looked earlier, the city attorney's offer that day was that if you were to plead guilty, and I'm just going to reflect on the by month 3, all loose property surrounding the house will be completely removed. There's nothing here about saying it's on the west side or the east side or anything else. It just says all loose property surrounding the house will
Get
be
rid of
completely removed.
all your junk.
But
So I want to
Not some of your
make
junk.
sure that
Oh,
everybody
no.
understands
but
that's in
all
fact what I put in my
your junk.
sentence. I didn't say property on the driveway or property to the west or property to the north. It just says all loose property around the house.
well, visible from the street is the a rule of thumb, or the rule that we have been told by code enforcement, that nothing from that's can be visible, no loose items can be visible from the street. Our contention is that that is the metric against which we have been towards which we've been working. Nothing visible from the street. And I would contend that, with the exception of the things that were pulled out of the garage, we've complied with that.
So I think you're
worse
putting
than
a
loud.
gloss on it that it was not in my order.
If that's possible, she is.
And it wasn't in the written plea offer that was submitted by Mr. Reynolds. You're putting a gloss of what you may have heard from code enforcement and what you believed. But all I can do as a judge is, when I hear a plea offer that's been made and the condition that that the prosecutor wants to be imposed, and it seems to be an agreement of the parties, then I reflect that as part of the sentence. And I was really clear in the record, all loose property around the house. I didn't say visible from the street or.
But Mr. Reynolds did say that repeatedly. Not
to me, but maybe to you. I don't know. So, Mr. Reynolds, you want to respond to that?
Your Honor, for today's purposes, for CR 24-2250, we are prepared to proceed on an allegation that she's not in compliance on the court's order purely on the east side of the house.
Okay.
Based off of the photographs that she has submitted to her probation officer.
So you're not going to rely on evidence of what's in the backyard?
That has to do with the case that I would suggest that we continue the arraignment of, and just focus on right now 24-2250 and just look at the pictures that she submitted to demonstrate compliance.
Okay, so hopefully that's what you were just suggesting, is you wanted to be what the court viewed. And if I hear Mr. Reynolds correctly, he's only pursuing an allegation that you failed to comply based on what is along the outside portion of the front part of the property, whether it's the north side that faces, forgot the name of the street. Sioux Drive or the west side that is on Pawnee. Those are the only two places that he's alleging that there's still a remaining failure to comply. So to that vein, I think you secured his agreement. And if he's in agreement with that's the only thing he's going to pursue in connection with this case as failure to comply, then I'm happy to make that the only condition that I look at. And then it would just be a determination of whether you are in compliance or not in compliance based on the evidence that's going to be considered here today.
Okay.
Does that make sense to you?
Yes, although I did have, I'm sorry, Mr. Reynolds was still sort of garbled, so I wonder if he could repeat maybe a little more slowly what he said he was willing to consider.
Oh, sweet Jesus. I'm going to lose it.
The city's position is that on the case from last year, not the new case from this month, but the case from last year.
In French, please.
The city will be able to demonstrate a violation of probation purely off of the pictures of the east side of the house. I'm not saying there aren't code violations on other sides of the house, but just that emails that Ms. LeCompte submitted to her probation officer in the city's view show that she is not in full compliance, and the court, and we can use those photographs to show the court that she's not in compliance with the court order on CR 242250. I'm not conceding that there aren't code violations on other parts of the house, but just that the photographs that you submitted to your probation officer, Ms. LeCompte, show that you're not in compliance.
And you're saying you mean west side of the house?
I'm sorry. Yeah, from the east. Yes.
Can you condemn this place?
The west side of the house. I'm getting my cardinal directions mixed up. The west side of the house, right? The Pawnee side.
I'm sorry, I was very confused about that as well.
Yeah, I know you were.
So he's saying that just the two photographs that you submitted to Ms. Aubrey that are now in our system, he's arguing that those do establish that you failed to comply. And what I would do is if everyone wants to simply rely on the photographs that you submitted, we could introduce those into evidence as part of this hearing. And then you could argue, if you chose to, Ms. LeCompte, that they show that you're in compliance, or you can argue that you're in substantial compliance, however you want to frame it. And Mr. Reynolds can argue that you're not in compliance, and it would be based solely on those two photographs that you have submitted of the west side of your property.
Judge,
Here's a hint. You're not in compliance.
you're
gonna lose.
You're muted.
Your Honor, this is Michael Lau. I'm the one who
Mr. Lau,
supplied
I don't want you
no.
speaking yet. I still don't want you speaking.
Judge, I have not seen these photographs. They
I
were
see.
taken.
Okay, well,
That's
let's
the
do
problem.
this.
Seriously, get the
Okay,
cards.
I understand. Mr. Lau may have taken these photographs. So I didn't realize that they weren't coming from you, Ms. LeCompte. And this is part of the problem with Mr. Lau's intervention in the case, is that Mr. Lau seems to, the mistaken impression, although I'm trying to clarify for him, he doesn't have the legal authority to submit documents in this case. If he wants to take photographs and give them to you, Ms. LeCompte, you can submit them, but he should not be submitting documents to the court on your behalf saying he's the defendant. And so they're uploaded as something that came from the defendant when they're really not from the defendant. And perhaps Ms. Aubrey didn't know that when she submitted them, because it just says defendant photo. And certainly I don't realize that when I'm looking at them. So I want to make it clear, and I've made this clear a few times, that Mr. Lau is not the defendant here. He may be interested in the outcome for you. He may be helping you come into compliance. He may even be the person who brought some of the property onto your premises. That's irrelevant to me. What's relevant to me is what's the defendant, Ms. LeCompte, doing about the circumstance. And so what I'm going to do is I'm going to have photograph number 1 come up, and I'm going to see if I can share my screen.
But Your Honor, I'm the one who supplied the February 24th photos as well. And the court accepted that. And of course, Mr. Reynolds used those.
Mr. Lau has a better camera than I have. That is why he has done that for me. And I do apologize, Judge, for
hey now.
this
Mr. Lau's got a BBT and a
shared,
better camera.
Submission. But the fact of the matter right now
Among
is
other
that I
things.
don't have those pictures in front of me. Okay.
Can you see it now?
Yes, I can.
So that's a photograph that the court has received that's been reflected as
Yeah, it looks awful.
defendant's
Horrible. You should be ashamed of
submission
yourself.
by the defendant. So that's
Shame,
a photograph.
shame,
It
shame.
doesn't matter to me whether it was taken by Mr. Lau or by you. If you decide that that's a fair and accurate representation of your premises, then it can be admitted into evidence. But I would have to have you sworn as a witness to do that. But I just want to show you what I've seen that's been submitted. That's the first one. I'm going to stop sharing. Have you had a chance to look at that? And
Yes,
I'll
I
share
did.
it
Thank
again.
you.
The other one is very similar. So let me go back to see if I have exhibit 2. I'll have to pull that up for a moment. Hang on a second. I don't know. Are you able to see this most recent one?
No, I can't
Oh,
see.
that's
a
the wrong
second.
document. Hang on a second. This is where it gets a little tricky. Let's see if that's visible to you. Hang on a second.
It looks like somebody else's
It
joint
is.
motion.
Yeah, it's strange because I can see the picture and then when I do that, hang on a moment. Let's see what happens when I do this. And I'm going to stop sharing.
Your Honor, Fernanda's going to attempt to share her screen with that photo.
I think I'm there. So that's the second photo. Are you able to see that?
Yes, I am. Thank you.
Okay, so that's the second photo. So how this would work.
And I don't object to, if Ms. LeCompte is okay with it, just submitting these as exhibits for the purposes of this hearing and not requiring her to testify to these as exhibits.
Okay, so Mr. Reynolds is waiving his right to even require that you testify. If you want to have those 2 photographs admitted for my consideration, then it would just be an opportunity for both Mr. Reynolds to argue how this fails to comply, and you could argue that you do comply. Does that make sense to you, Ms. LeCompte?
Little insider tip here. When the prosecutor says we waive all objections to the admission of your exhibits, they're not helpful to you.
Yes.
Okay. So with that stipulation, defendant's exhibits, and we'll call these defendant's exhibits A and B. The first one that I showed you was a moment ago. That's up right now is defendant's exhibit A. And then the second one will be defendant's exhibit B. I'm going to leave exhibit A up. I think it's the one that gives me the best view. Both A and B have been admitted. Mr. Reynolds, would you like to make an argument?
Yes, Your Honor. And if it's okay with the court, I might share my screen so I can control and zoom in on this photograph.
That's fine. I'll stop sharing and allow you to use your screen.
And Your Honor, Ms. LeCompte is currently under the court. Let's see. Why is it not sharing? It says that I'm screen sharing.
That's all that can be said, KDM. It really is.
Oh, I know why. I was in my breakout room. All right.
Joys of technology. They help us and hurt us.
Not sure where to go. Okay. So, Your Honor, Ms. LeCompte is currently under your court order to remove all loose property around her house. And if you look at the photograph that has been submitted by Ms. LeCompte of her house, you can see much loose property remains right outside her front door. As you can see my cursor circling a bunch of loose property. As if I pan right, all surrounding the juniper bush, multiple hoses, just various discarded items. So I keep panning to the right, you can continue to see the loose property around Ms. LeCompte's house. Some various types of machinery. There is a refrigerator. There is some construction equipment. And then if you look at the second picture,
That'll be Exhibit B.
which I believe was this one.
There shall not be any cutting of trees.
I apologize, it's the same. The second picture. And then you can see on the second picture that we have not looked at yet, it goes a little bit more to the right. You can see that there's even more loose property over here, hoses, various items. So even this seems to be in about the same state, if not a little bit worse, from what she was at on February 24th. That just on this east side, you can see from the front door across to the juniper bush, across the garage, there's still much loose property that remains. All the parts of the house that are visible, this part is blocked by the juniper bush, but you can see this large white container as well with things piled on top of it. It would be logical to assume that this pile of things extends across the front porch to the house. There's just still loose property remaining. And you can't quite see it on the Zoom
I
screen.
have to shut up. Come tell me.
You can't see it on the Zoom screen because the blacks are a little bit too dark, but there's just loose property still all around the house. It looks better than it has looked, but it's still not, there's still loose property that is not in compliant with the court's order. And given the state of the property that the court has seen it in, the city would suggest to the court that even allowing, this amount of loose property, which is better, but it's still a lot, more than one truck full worth, is too much, and that she's not in compliance. And so the city would ask the court to impose part of the suspended sentence that it's already imposed on Ms. LeCompte to demonstrate that when the court says all this property must be removed, that is a clear direction, and any normal observer of reasonable mind would say that this is still a lot of loose property around this house and it needs to be removed, and it hasn't been, and it's been months.
Okay, thank you for that, Mr. Reynolds. Ms. LeCompte, it's now your opportunity, and we can do this one of two ways. I can put up the exhibits if you want to discuss them, if you simply want to make an argument based on what you've heard from Mr. Reynolds. But he put up both exhibits, went through them, showed what his position is with respect to the property. If you want me to put them up, I can simply put them up for you, and then you can tell me where to move it so that you can show me what you want me to see.
Why don't you put up one? They're fairly similar. So why don't you put up the one that shows that's the furthest south?
The furthest south. Okay, so I believe that would be Defendant's Exhibit B, but tell me if it is one. I'll share right now and you tell me if that's the right one, and we'll go from there.
It's the one that shows the garbage cans.
Okay. I'm going to share this real quick, see if it's the right thing. 'Cause nope. Share. Is that the one?
Well, that'll do. I think so.
Got the garbage cans here on the right. Can you see
Yep.
my cursor?
Yes, yes.
My hand there, there's the garbage cans. There's the items that Mr. Reynolds was describing. There's the juniper bush. There's the items that are behind the
My
juniper
hand
bush.
there.
There's the items on the porch, things of that nature. And
Okay.
all right, what would you like to say?
Can you see my cursor, the little arrow right here?
Well, you're not going to be able to mark on mine. So no,
Okay.
I can't, your
Okay.
screen's not being shared. Mine's the one that's being shared, but
Okay, then let me just describe the things.
sure.
Right at the corner between the carport and the house, there is an upright blue piece of metal. That's a hoist.
Okay.
And that is being used to move the very heavy items like the refrigerator,
Mm-hmm.
which was in the carport and is being loaded into and moved to the extra storage space. That's the name of the company on Arapahoe that I have reserved quite a lot amount of space to receive the things that we are taking away from the house to be stored there. And so
The
that
Chisinator would have this done right
refrigerator
now.
came out of the carport area
Just
to
saying.
make
When you say
more room.
carport, do you mean garage or what do you mean by carport?
Where the white doors are,
Okay,
that's actually a carport.
I see. Okay.
Okay. And those doors aren't original with the house, but anyway. So we needed to make space to put the two green boxes that you see to the left of that, some tools and things that are right up against the back of the house, which Mr. Reynolds objected to last time, and to put them in the carport area or in the garage itself. And the same thing is true. There's a behind the garage, the garbage cans is a ladder that is also being used to move things and stuff. So that is and those are basically things that are in the process of being shoved around so that we can actually comply with what Mr. Reynolds said was missing last time. The hoses and things are things that we have used to water our trees. And Mr. Reynolds said before that was okay.
Yeah, we use
to
the
have
hoses.
tools and stuff
Okay.
things like garden hoses and stuff. There are a number of things between the brick column and the juniper
Garden hose.
on the
Mhm.
porch.
Yes.
There are some things that were moved again out of the garage and are being taken to the extra storage space so that we
I
can
like the
actually
specific
put
call out.
things so that we can actually get this completely cleared off. As is what I am being asked to do. So I can understand that this doesn't look like complete compliance. But what I would like to argue
Yes.
is that
Does
this is
not look
not
like
willful
complete compliance.
non-compliance, but that we have been working extremely hard to try to
You
find
got that right.
places to get rid of things that we really don't want, to store things that we really would like to keep, and make the whole front of the house and the side yard as well be free of anything other than yard equipment like hoses and garden tools and things like that, and so forth, and the porch swing and the chairs that we sit in, things like that. In other words, yard furniture.
So I'm maximizing mine and then moving it so that you can respond if you choose to talk about any of the things that are over here where I've got my cursor. There's a number of things over there.
There's a couple of boxes right towards the front of the patio. We had put so much stuff into our trash bins that our recycle bins, that the city didn't pick it up last time. So there's
Ma'am, are
two
you a
boxes
whore?
of empty aluminum cans and plastic bottles, things like that, that are going to go over to excuse me, EcoCycle to be taken away, but they weren't hauled away in the last trash pickup, which was on Friday.
Once
There are,
again,
I
it's
can't really
Boulder's fault.
tell other things. There's some watering cans
The city of Boulder would do
that
their
are
job. All
used
this would be
to
fine.
water some. There are
What about all this that I've got my cursor on over to the far left of the screen? See that area that I'm
and
circling?
blew onto our card. See right there.
Yep.
What you're circling, yeah. Those and a couple of other things blew into our, probably this during the heavy winds last night and this morning, which I haven't had a chance to remove.
The
So
winds,
I mean,
the
I
pickup,
can't really see absolutely everything well.
the fines.
but,
Everyone's
Looks to be
conspiring
a
against.
tire there. There's
I
some
think that
boxes.
the boxes I was talking about that were full of recycle are to the right of that. There's some sort of diagonally, there's a to the far right of this photograph, there is a big box and a big diagonally, well, that's the box.
They need the
And
big
that's what you're
bag.
talking about when you say far
BBT.
right over by the trash cans, or just far
No, I'm
right?
talking about on the other side of the still on the patio.
Okay. Right in here?
Nope, keep going.
More to the right?
More to the right. No, I'm sorry, shit.
To the left?
No, to the left.
This area right here.
That's that area right there. That has blown in.
But what
You
about,
filling in for
that looks to
Andrew?
be a tire right there. That didn't blow in, right?
No, that is not a tire. Yes, that is a tire, and that is. I'm not quite sure where that came from.
And there's a crate of some sort and some stuff on a crate. Doesn't look like the type of thing that would blow in.
No, there is a galvanized pail that has a dog food in it that we use to feed our dogs outside. On top of that is a box that I just brought home last night from a party that had I carried a fruit cobbler in it to put into my car, and I didn't remove it this morning.
Okay. All right. Anything else that you'd like to comment on
Yeah,
before
the
we,
fruit cobbler defense was solid. That you
before I
really
make a
can argue
decision
with.
here?
Your Honor, may I speak?
Not unless she wants to call you as a witness. If she
I
wants to
asked,
call you as a witness, I'll swear him in, and then keep in mind that Mr. Reynolds will have a chance to ask you questions.
I did ask earlier to, and it may have been to Chris, Mr. Reynolds, if Mr. Lau could be admitted to help answer some questions.
So would you like to call him as a witness?
Yes,
All right, Mr. Lau, why don't you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Right. I'm not going to require that you ask him questions, Ms. LeCompte. Mr. Lau, you can simply just
he's
give your
happy.
testimony, and then when you're done, keep in mind that Mr. Reynolds will have an opportunity to ask questions if he chooses.
Oh, he is happy. She called him.
Thank you, Your Honor. So I am the one,
She'll get some
and
later
of
for
course
that,
it's
from what I'm
verified by
saying.
the email that was sent in for the photos for the February 24th, as well as the 2 photos today.
Okay.
But first of all, I would like to clarify that I guess I did not send it in the longest, highest resolution, but it's not a tire that you've been referring to.
Resolution isn't the problem here. Wow.
Those are actually the 2 black things on the ground. If you can zoom in even closer, and of course, and I actually went and double checked because I know I don't have a tire there. It's actually 2 batteries that I am just in the process of charging and moving them out of the way. Of course, nobody would keep 2 batteries there for no good reason. So though that it's not a tire in any sense.
Okay.
Okay. But once again, back to February 24th. I was,
let's go item by item and hear your rationalization.
And I was most pleased that Prosecutor Reynolds said nice things, kind things, and nice things about the condition of the driveway and so forth. But he really voiced concern that that there was a wooden bench with some tools on it and a snow shovel.
I forgot about that.
That was in front of Your Honor, kind of directly west of that hose reel that you were referring to earlier. And he was most concerned that that was there. So as you can see, whatever that wooden bench and the tools and whatever, it was no longer there. And you can, of course, refer to the photo that was entered into evidence on February 24th. So once again, I was most pleased with what Prosecutor Reynolds said that day. But to me, it's a continuing shifting of the goalposts, shifting of the requirement that if one can compare the 2 photos from 24th and also today, you can see that there is even a significant improvement. So, and yes, Your Honor, while it is true of what was your ruling on October
No improvement.
8th,
it looks like crap.
It is
Get out.
Still my understanding based on February 24th that the defendant and me, the interested party, is making very good progress. And today, of course, we've demonstrated that we've made even more progress. But with Prosecutor Reynolds now referring back to, of course, to your original judgment, all loose items, and of course, and with 633 even includes recyclables and so forth. It's even having anything recyclable for trash pickup and whatever could potentially be in violation of 633. So with that, Your Honor, I refer back to the defendant and the court. Thank you.
Mr. Lau, before you leave, are you wanting the court to, well, Ms. LeCompte, if you're still there, Ms. LeCompte?
Yes. I'm sorry, I didn't hear what you asked me to do.
Mr. Lau referenced the February 24th photograph. Are you wanting me to pull that photograph up and share that with Mr. Lau so that he can add additional testimony?
Oh, yes, that would be okay.
Give me a moment. I'm going to stop sharing on that screen so I can bring the other one up. And I'll take a look at what we had. I think that may have been at the January. Let's take a look. I think this might be it. Everybody see that?
Yes, I can see that.
Okay, Mr. Lau, did you want to continue your testimony? This is the photograph from February 24th. We're going to call that Defendant's Exhibit C for this hearing's purposes. Any objection?
Yes, Your Honor, I would.
Let me just check with Mr. Reynolds. Mr. Reynolds, any objection to Exhibit C being admitted?
No, Your Honor.
All right, Exhibit C is admitted. Go ahead, Mr. Lau, if you want to talk about what you see there.
So, thank you, Your Honor. Once again, that was a photo that I've taken and sent to the court, and that has been entered. And it was while I did join late at court via Zoom. I was most pleased, and of course, I expressed my great pleasure and appreciation for Prosecutor Reynolds, saying that it's a tremendous improvement. And of course, I did explain the stuff at the corner of the so-called carport, tools that I need to fix the truck once I'm a little bit more mobile. Mr. Prosecutor Reynolds was very specific on the bench, not quite where your cursor is, Your Honor, but sorry, a little bit more to the north of, yeah. Okay, close enough to, yeah. So that being the wooden bench with tools and actually several small sheet of metal leaning against it. And
it's horrible. What are we talking about?
Yeah. So and of course there was a snow shovel right in front of it. And of course, Mr. Reynolds was very specific and said he's very concerned. Of course, I don't have photographic memory. But something the transcript or the court recording would show that he's very concerned if the snow shovel or whatever does not either get removed or things get accumulated in that specific area further and so forth. That would be his concern. And of course, we also, as you can even see from this picture, there is still significant water, and it's because of the flooding that happens both in the garage and in the carport area. And that was brought up with the court as well. And I thought that was also well understood by the prosecutor and the court. So with today's picture, which have been submitted as evidence, I believe there is no such pile of those things. And we have, as the defendant has stated, in order to move things out of the garage to deal with the flood and the stuff that's been wetted, and the city garbage and trash or recyclables removal would only remove so much at a time, which is every 2 weeks for recyclable or compostable, but that's another separate issue. So we have definitely, because Mr. Reynolds specifically mentioned that, we have specifically addressed that, and to hear today a shifting requirement again. I, as the interested party, just remain at a loss and on how one can possibly fulfill an ever-shifting criteria by the prosecutor. Your Honor, yes, I do recall and I do understand what your order is on October 8th. I wasn't a defendant.
Object. This isn't factual testimony. This is argument.
Yeah, let's just talk, let's just stay focused on what you're wanting to testify about the state of the property today and on February 24th. They're both relevant to me.
Okay, so just to quickly summarize, the picture, the photo in front of us, of course, right now is from February 24th, and Exhibit A, which has been shown earlier, shows a drastic marked improvement from this photo, and it also addressed the wood bench and with tools and things leaning and the snow shovel that Prosecutor Reynolds referred to specifically on February 24th. And with that, Your Honor, I rest.
Your Honor, could I add one other thing regarding those photographs?
You can, and I've shared basically Exhibit B from today's date that was submitted. You can go ahead and any other comment you'd like to make, but I'm going to hold off for you, Ms. LeCompte, because Mr. Lau just testified. I want to just check any questions. I want to make sure Mr. Reynolds didn't have any questions for Mr. Lau. So go ahead, Ms. LeCompte, you can make any further statement you'd like. And now you're looking at the photograph for today's date.
I'm sorry, are you wanting, is Prosecutor Reynolds going to speak now?
No, it's your turn. I wanted to make sure he didn't have any questions for Mr. Lau, and he does not.
Okay, there are a number of other tools and things that were removed. There were several dollies next to that refrigerator that we're planning to move, and a couple of other things like that. So I just wanted to add that.
Okay. Any other evidence or argument that you'd like to make, Ms. LeCompte?
No, other than to say that I share Mr. Lau's consternation as to how we are going to comply at the rate that that Prosecutor Reynolds would like, and also to reinforce that is a rate that we wish we could do, but we are not entirely able to do that. Judge, I don't know that you heard me explain to Mr. Reynolds that I've hired people, I've brought in, I've gotten additional storage space, and we've rented a large truck to move things, and that's about the capacity that I have. I would very much like to wave a magic wand and make it all go away, but I'm not in a position to be able to do that.
Okay. I've heard the evidence. I'm going to treat Ms. LeCompte's testimony as basically the evidence for the hearing, and then I'm going to give both of you a chance to argue in conclusion, a short argument from the prosecution as to why you believe that she's failed to comply, and then any additional argument that Ms. LeCompte wants to make is an argument that she is in compliance. Go ahead, Mr. Reynolds.
Thank you, Your Honor. In October of last year, the court ordered Ms. LeCompte to have all loose property around her house removed by January 6th of this year. We're now approximately 13 or 14 weeks after that date, and the pictures that Ms. LeCompte sent her probation officer this morning demonstrate that they're on the west side of the house, that there is still a lot of loose property. She's describing what the property is, but it's still loose property in violation of the court's order. So we would ask the court to impose a similar consequence that it did in January of this year for non-compliance with the court's order. A giant refrigerator, a bunch of boxes, a bunch of other sort of trash. And it looks like you're just getting closer and closer to the house. And just because they moved the pile that was in front of the juniper bush, if we compare it to the February 24th photo, it looks like there's now just more stuff behind the juniper bush. That is not good enough. And for Ms. LeCompte to say that she doesn't understand the court's order when it's just remove all loose property around the house. It just doesn't get more simple than that, and we're just months after the point in which this property needed to be in compliance.
All right, Ms. LeCompte, any additional argument that you'd like to make?
I do understand what the court's order is. My statement about consternation was that it is what I am finding it hard to do is not to willfully not comply, but to actually, under the circumstances the constrained circumstances that I have, both financially and physically, I am finding it difficult to comply very rapidly. I fully understand what the court's order is, and I am fully in sympathy with Mr. Reynolds' desire to have this done and over with, as I'm sure you are too, Judge. But and I know that saying I'm doing the best I can is not a good legal excuse. However, that is the case. I would really like to have a little more time to do the reorganization of our garage space so that much of this can completely disappear. I can't do that right now. I mean, I can't do that in this very minute. And anyway, that's all I have to say. I do apologize for this.
All right, I'm going to pause for a moment. I'm going to gather my thoughts, and then I'll come back to you. So I'm going to pause the screen here, and then give me about a couple minutes. I just want to organize my thoughts, and then I'll come back and let you know what I've decided.
My thoughts are organized on this. I'm still with the dart. Sleep and
Okay,
sweet.
we are back on the record, and I'm going to briefly go through where we've started with this case as far as the court's involvement, and then describe what we've determined today. On October 8th, defendant pled guilty to the charge of accumulating trash, in this case number 2024-2250. The court imposed a $2,650 fine, also imposed 80 hours of community service, suspended both on the condition that the defendant have no loose items along the property as of 3 months from that date, which would have been January 8th. On January 16th, a hearing was held. At that hearing, I did find that the defendant was not in compliance, that there was property that was along the premises.
Dart,
And at
J-Dam,
that point, I reinstated the $2,650 fine.
professional
I
cleanup.
suspended $2,150 of that fine and 64 hours of community service on the condition that the defendant bring the property into full compliance by February 24th. On February 24th, the defendant appeared and provided a photograph, which we are now calling Exhibit C. I'm going to share my screen and show what Exhibit C looked like. And that was Exhibit C as of, and which was a photograph of the property on February 24th. The court did not zoom in on that photograph, nor did anyone else zoom in on that photograph that was submitted on February 24th. And perhaps if we had, we would have seen some debris and property that was up along the front porch of the house and that was behind the juniper bush. We might have seen more if the court had zoomed in on that. And there may have been a different perspective of the court at that time. But it looked so much different on February 24th than it had looked either on January 16th or on October 8th. It was a dramatic improvement, especially if you looked at it simply from the photograph that was submitted, which was not zooming in, but just that photograph, seeing a few items of property along the driveway and a few items on the property. And the defendant, by the description, was that there'd been some water, there'd been some challenges, and that they were making great progress. So at that point, on February 24th, the prosecution made some comments about being satisfied with what the progress that had been made, with the exception of some items of property that appeared at the side of the driveway, and not really focusing on what was behind the juniper bush or along the porch. But as you look, now that we zoom in, there were some items of property that were there, even more now, and I'll bring up the March 17th photograph, but even more now. And there was still, even on February 24th, there was this refrigerator that was sitting there. And so still some items of property, but great progress, and no one's disputing that. And so that's why the court was hopeful that by today's date, the property would be in compliance such that there would be no need for any follow-up hearing. And I'm going to now turn to pull up Exhibit B, and I'll share my screen on that one. And so Exhibit B is now a photograph of that was again provided by the defendant for today's hearing of the property as of today's date, March 17th. And the items of property that were here along the side of the driveway are no longer at that location, although it appears that they've been moved. Not all of them, but it looks like some of them have been moved to other places on the property. And there are now some containers here that I'm circling. And then if you zoom in and you go to the back porch, you can see behind the juniper bush, there's items of property. There are items of property along the north side of the juniper bush, which includes buckets, a tire, some boxes. If you get really zoomed in, you can see that there are some other items back there as well. And then to the far north end, there's a cardboard box, but there's also some items that have been identified as batteries, and it looks like another container that's here. Other items of property that are loose, items of property that are on the property. And so there is not full compliance. And perhaps it's because the prosecution and the court were so excited to see substantial improvement that we didn't dig further and actually look and see what was still on the property. But that did not mean that those loose items that were there were not something that the defendant was aware that are there. Those were there. She's responsible for knowing what's on her property. And coming into full compliance means what it meant in October, that there's no loose items of property. Giving full benefit of the doubt to the defendant, perhaps she was misunderstood and perhaps thought that if she just moved things and had them behind the juniper bush or along the porch, that somehow would have been compliance. The order was very clear, and the prosecution's plea offer was very clear in the court's mind. But nonetheless, giving some benefit of the doubt to Ms. Lecomte, that perhaps she thought that it would be okay if everything was simply behind the juniper bush and up on her porch. That's not what the order said. That's not what the court was anticipating. And any misunderstanding about that I'm going to clarify right now, and is that all items of property means all items of property visible to the public. And that means if it's on your porch and someone can walk by and see it on your porch, then it's visible to the public. And if it's an item that you need to use to help you get other items off the property, it can't sit out there while you're working. It has to be put away in the garage, or put away somewhere else where it's not visible to the public. It can't sit out there while you are in the process of moving other property. That's not a legal defense to having all items of loose items of property off the property. Your mechanism for getting things off is whatever mechanism you choose to use, but it can't mean that from day to day, I'm going to have a whole bunch of things out on the property. And so that's where the court is concerned that perhaps the message is not been received as clearly as it should have been received. And it means all items of loose property. I am convinced by a preponderance of the evidence the defendant is not in full compliance as of today's date. I also believe that the defendant is making efforts to come into compliance. And so what I'm going to do is I'm going to impose.
I don't.
There were 64 hours that were remaining. I'm going to reinstate those 64 hours. I'm going to impose, again, 16 hours of that, and I'm going to reinstate the $2,150 fine, and I'm going to suspend $1,650 of that, which would leave a $500 fine and 16 hours of community service. The difference is what I'm going to do today that I didn't do at the last hearing is I'm going to stay execution of that. That means that you don't have to pay that $500 today, and you don't have to complete that 16 hours of community service today. I'm going to stay it for 2 more weeks. And I'm going to give you the chance, Ms. LeCompte, to satisfy me on the next court date that we set, which will be about, give or take, 2 weeks, that everything that's on that porch,
appointment,
that everything that's along that driveway, and let me go back to my screen and make sure that it's showing. See if I can get this back up. So everything that you see there, let me make it a little smaller. We'll start with and I'll start from the right. Trash cans. If I just saw trash cans and nothing behind them, a trash can and a recycle can, I'd be okay with that. But this is a loose item of property, this refrigerator. These tools are loose items of property. They need to be moved somewhere by the next court date. They can't just sit out there. These bins are loose items of property. These things that surround the bins are loose items of property. If it were just one garden hose, I could look, that's okay. That's an item of property that typically has been allowed on people's property. And Mr. Reynolds had previously said he was not going to be objecting to a hose and perhaps your trash cans. But whatever is back in here, I can't quite tell what it is. But there are items of property that are here that need to be removed. And whatever is back on the porch that are loose items of property, those need to be removed. And whatever is up here on this side, on the north side of that juniper bush, and what's behind the juniper bush, those need to be removed. These buckets need to be removed. Whatever this wheel is, I don't know exactly what it's attached to, but it needs to be removed. And these items back here, the batteries or whatever else they might be, they need to be removed. And if not, then when I next see you, you'll be required to pay the $500 fine that I've suspended and do the 16 hours of community service. And we will have another hearing to determine whether I should reinstate more. I don't want to do that. I also have great empathy for you because I know that you physically, it's not as easy for you, and perhaps financially, although you haven't specifically said what the financial challenges are, you've mentioned them, are perhaps part of the reason. But from the court's perspective, I'm speculating on this, but from the court's perspective, there's an unwillingness to let go of items that have no real value, and you're just shuffling them and moving them because for whatever reason, you can't let go. And this is a personal aside, but I'm cleaning out my mom's condo right now. And my wife is and I are having to let go of a lot of things. They have sentimental value to me, but I can't keep them. I can't move them from my mom's condo to my house and put them on my front porch or put them somewhere else in my backyard. I can't. I have to let go. And sometimes if it's a financial reason you think they have value or a sentimental reason, you have to realize that you have to let go. And you have to get rid of things, as hard as that might be. And it gets easier when you start letting go and saying, it's not the things, it's the memories. If it's if it's about an emotional connection, and if it's about a financial connection, the cost of paying fines and the cost of moving them and paying for storage
we're past
has to be greater than the actual value of a lot of these things. And so that's me empathizing with you, Ms. LeCompte and Mr. Lau, but also trying to be real with you. These things don't have the value that you think they might have. So the good news is I'm not making you pay today. Nick's looking in the computer as we speak. I'll let Ms. operate this. Let's talk about the next hearing date so that we can put it on my calendar and we can put it on everybody else's calendar, because it's going to be both an arraignment, but we've already advised her of her rights. We're not taking a plea on the new charge, and we can put it on my docket about 2 weeks from now. I want to give enough time. So today's the 17th. Let's look into the first week of April. And we could do April 7th. That would be that we can change that April 7th jury readiness conference to another hearing date. Mr. Reynolds, is that a date that you would be available?
What time is that, Your Honor?
April 7th at 2:15. Much the same as today.
Any chance of going a little earlier? I completely blew through my afternoon meetings today.
Oh, you mean earlier in the day? Yes.
Earlier in the day.
Early in the afternoon. Yes, it looks like let me just double check that I don't have any meetings scheduled, but we don't have anything after our jail dockets. We could start as early as 1, but let me just double check that I don't have any. And it's a little hard because I don't have my calendar up in this courtroom. I'm going to assume that we can do April 7th at 1:15. I'm going to pause for a moment. Would that work if we did it at 1:15? Or even 1 o'clock, Ms. LeCompte, on April 7th, and then I'll go double check. I don't have anything on my calendar.
Your Honor, I am supposed to be at a conference that week in Portland, Oregon.
We could do the week before. We could do the 31st. That's 2 weeks from now. I could also do something.
I'm sorry that for me, it would have to be later because I'm leaving on the 30th to go to this conference and not returning until after the 7th. If I could move it a week later, that would work.
That's a pretty far down the road. Mr. Reynolds, you want to be heard on that?
So it sounds like you're coming back on the 7th, Ms. LeCompte?
I'm coming back on the 7th, yes.
Let me look at the calendar. So we could conceivably do something on the 8th. I've got pretty much I could do something as early as 11 a.m. on the 8th of April, or 1 o'clock on April 8th.
1 o'clock would be my preference.
1 o'clock on April 8th would probably be the court's preference as well. Ms.
That would work
LeCompte?
for me.
All right. That means you got to make some progress before you leave on March 30th, because you're not going to have any time on April 7th.
I understand that.
Okay.
So this is the April 8th at what time? 1 o'clock?
At 1 o'clock.
Okay.
Pause for a moment, because I'm gonna step aside for a moment. I want to go look at my personal calendar, because it's not up here in this courtroom. So I'll be right back. Okay, I'm back. I checked my calendar for April 8th. It's clear, so we can do it 1 o'clock on April 8th. We'll be doing both things on April 8th at 1 o'clock. We'll be addressing where things stand for the front part of the property with respect to case number 2250 from 2024. And then we'll be addressing how you'd like to proceed with the new case number 2025-1045. I'm not taking a plea. I've advised you of your rights, but we're not taking a plea today or anything of that nature. I just want you to be on notice that you'll be back that day. I'm going to ask our probation staff to at least give you the application for the public defender, so that if you want to have public defender representation, you could make that application and I can make a determination as to whether you're eligible. I don't know whether you will be or not, but we'll have them email that to you, or if you need a hard copy, they can put it in the mail to you, and then you could fill it out and then you could send it back to us.
Okay, thank you very much.
Okay. I'm trying to give you some grace here, Ms. LeCompte, which is that I could have just imposed this in 16 more hours of community service and the $500 fine. I'm trying to give you just a little bit of grace to get this thing wrapped up. You made some good progress. I think less than we thought you'd made, but you made some good progress. I think your intentions are perhaps to get into compliance, but you got to just carry it forward and get it done. It's been going on for too long, and you can do this. I know between you and Mr. Lau and anybody that you hire, you can get this done, and then we can stop meeting like this.
Okay, thank you.
All right.
Thank you, Your Honor.
Let me just, yeah, you're welcome. Let me just pause. Ms. Bittencourt, or Ms. Aubrey, do you need to see Ms. LeCompte, or can you just email her the setting notice?
We'll email her the setting notice
Okay, good enough.
and the form.
Yes, perfect. Okay. All right. Thank you.
Good Lord. We've got 2 more hearings, people. I'm doing them. But I'm losing my mind. I really am. But we've come this far. We're going to get to the end of this saga. The thing is, though, there might be 20 more hearings before this is over. We're catching up to real time, but that doesn't mean it's over. Oh, good night.